Chapter 15, Personal Defenses or Equities. Section 142, Personal Defenses or Equities. In general, the real defenses are such, that the party who has a right to set them up, can set them up against anybody. Every other person does not necessarily have a real defense because the party originally liable does. The real defense is one which the person alone who has it may set up. So, when we say that a real defense is an absolute defense so far as the person who is entitled to the defense is concerned, we do not necessarily mean that that extends to the other parties. A personal defense is of an equitable nature. It is a defense which depends upon circumstances. It is a defense which a person has a right to set up under certain circumstances, and those circumstances are dependent upon whether or not he had notice and whether or not he was a purchaser for value. In the real defense, it is not a matter as to whether the person is a purchaser for value and had notice, and the like. The defense may be set up regardless of these facts, but a personal defense cannot be set up that way, since as to such a defense a person must show that he has not had notice and that he is a purchaser for value. As to equities or personal defenses, it is important to know who are to be regarded as the immediate parties, or parties between whom there is a privity to a negotiable instrument, and who are remote. Among the former may be classed 1. The drawer and acceptor of a bill, or 2. The drawer and payee of a bill as a general rule, 3. The maker and payee of a note, and 4. The endorser and immediate endorsee of a bill or note. That the bill or note has been lost or stolen or was executed under duress, or under fraudulent misrepresentations, or for fraudulent consideration, or for illegal consideration, or has been fraudulently obtained from an intermediate holder, or been in any way the subject of fraud or felony, or has been misappropriated and diverted, or that it was given as collateral security, or for a loss for which the party was not liable, or that otherwise it was without valuable consideration, is a good defense as between the parties privy to it. And in some cases it is a good defense that it was given by mistake for too great a sum, or when no sum was due, the evidence showing fraud or a total or partial want of consideration. As between the immediate parties on a bill or note, no question arises whether the defense is real or personal. Any defense is valid as between immediate parties if it would be valid on an ordinary contract. But when the parties are not immediate, then the question arises as to whether it is a real or a personal defense. Personal defenses being in the nature of equities, two principles of equity apply to them. 1 is, he who comes into equity must come with clean hands. He must not be a party to any fraud, to any illegality. If he has notice of any of these, he does not have clean hands. 2. The other is, of two innocent parties, he whose act or omission has caused the loss, must stand it. Equity says, as between two innocent parties, the one should suffer whose act or omission has caused the loss. If a person has no notice and he is the party who has made this loss possible, there can be a recovery against him. Where a paper is in the hands of a custodian, the rule is the person who enables the fraud to be perpetrated must stand responsible where the instrument is gotten possession of in such a manner as to amount to a forgery. It should be a real defense and no recovery should be permitted against it. Here, however, we find a conflict of authority. The better opinion is that if you can show that it amounted to a forgery or was obtained by duress, there can be no recovery against you if you are the person liable on the instrument. The negotiable instruments law provides, the title of a person who negotiates an instrument is defective within the meaning of this act when he obtained the instrument, or any signature thereto, by fraud, duress, or force and fear, or other unlawful means, or for an illegal consideration, or when he negotiates it in breach of faith, or under such circumstances as amount to a fraud. Section 143. Fraud. Where the consideration for a bill is clearly fraudulent, it is a good defense against an immediate party or a remote party unless he is an innocent holder for value. And while the instrument is yet in the hands of a party with notice, a court of law will compel its surrender, or restrain its negotiation until the question of fraud is settled. A bill is affected with fraud when the issue or any subsequent negotiation of it is obtained by fraud, coercion, or when it is negotiated in breach of faith, or in fraud of third parties. No holder of a bill subsequent to its being affected with fraud can enforce payment from any party thereto, or retain the bill against the rightful owner unless he received it from a bona fide holder for value without notice. The question of fraud is largely one of negligence. Did a person who has signed the instrument and let it get into the hands of other parties, or into circulation, act with negligence? If he did not, then fraud is a real defense, but if he did so act, it is a personal defense. Where a person, in case of fraud, signs an instrument believing he is signing a different instrument, if he was negligent he cannot set up the personal defense. Then, in case of delivery through fraud, where an instrument has been delivered to an agent or an agent has fraudulently delivered it to someone else, fraud is not a personal defense, because the agent was entrusted with it. As to a custodian, the general law applies the same. The maker of the instrument would not be entitled to set up the fraud, and, where the instrument has been stolen or wrongfully taken, then the question becomes largely a question of negligence. If the party has been negligent, then he has no right to set up fraud as a personal defense. If he has not been negligent, then other circumstances not being considered, he could not be recovered against. Section 144. Alteration. The following is the provision in the Negotiable Instruments Law, where a negotiable instrument is materially altered without the assent of all parties liable thereon, it is avoided, except as against a party who has himself made, authorized, or assented to the alteration and subsequent endorsers. But when an instrument has been materially altered and is in the hands of a holder in due course, not a party to the alteration, he may enforce payment thereof according to its original tenor. A material alteration is defined to be any charge in the instrument which affects or changes the liability of the parties in any way. The alteration avoids the paper regardless of whether it is favorable or unfavorable to the party making the alteration. The following have been held to be material alterations: any change in the date of the instrument, but not in the date of the endorsement; any alteration in the amount of principal or interest; any change in the character of the payment, whether in the denomination or medium of payment; any alteration in the personality, number and relations of the parties; any change in the liability of the parties, or any change in the place of payment. The addition of the name of a witness to an instrument required by law to be witnessed is a material alteration, but if the instrument need not be witnessed, or if it already has on it the number of witnesses required by law, the alteration is immaterial. An innocent alteration, when material, is held by some authorities to avoid the instrument while not cancelling the debt, others holding that so long as the alteration has caused no injury a court of equity may restore it to its original condition so that suit may be brought on it. When the change in the bill or note is made by a stranger, it is called a spoliation instead of an alteration. Such a change of an instrument has no effect upon it, if the original meaning can be ascertained. That is, if the alteration be made by a stranger to the instrument, the rights of the parties are not affected. Immaterial alterations are those which do not change the legal effect of the instrument, as adding words implied by law, making marginal figures to correspond to the written statement in the body of the instrument, the adding of immaterial memoranda, and the like. Thus the correcting of a mistake to conform to the intention of the parties is an immaterial alteration. In those jurisdictions which have not adopted the Negotiable Instruments Law, the law is generally as follows: bona fide holders are only protected against material alterations discharging the party liable, when some carelessness or negligence on the part of the person whose liability has been changed by the alteration, has contributed to the negotiation of the paper without suspicion of fraud, as where blank spaces have been left, or it is written partly in pencil so as to be easily erased, so a memorandum which can be detached without affecting the paper will, when detached in fraud, not be allowed to avoid the paper in the hands of a bona fide holder. In those jurisdictions the effect of a material alteration by the holder of a bill is to discharge all parties from a liability on the bill, unless they consented to such alteration. Section 145. Duress. Duress, under most circumstances, is considered a personal defense. The abuse of any process, either civil or criminal, to compel a party, by imprisonment, to do any act against his will except to pay the debt for which he is arrested, is entirely illegal, and the act may be avoided. on the ground of duress. Thus where an arrest was without any warrant or lawful authority and a note was signed under such pressure. Duress is a perfect defense to an action between the original parties and parties having notice of it. Section 146. Want or defect of consideration. The largest number of defenses concern consideration. Anything which is a good consideration in a contract is a good one in a bill or note, or a negotiable instrument. If a person has bought something and agreed to give something in return, the court will not look into whether he has gotten value. The courts do not look into that, but the court will look into some other matters. If there has been no consideration whatever, the court will look into that as between the immediate parties. That is a personal defense. As between the parties, one who has notice of want or failure of consideration, that is a defense the maker can set up against him. For instance, a makes a promissory note, and gives it to B as a gift. There is no consideration, only thereby promises to give B $50 in the future. As between the parties there can be no recovery, but if A gives B a note of a third person, it is held there is sufficient consideration and B can recover from that person, but he cannot recover against A in the first case on account of the want of consideration. By failure of consideration, we mean something which apparently had a good consideration, but for some cause or other the consideration has failed. A thinks he owns a certain piece of property, but there is a judgment against him and execution has not been taken and A conveys that property to B for B's note. In the meantime, the property is taken on execution. There has been a failure of consideration and that note could not be recovered upon. Want of consideration is matter of defense as against any person not a holder in due course. Partial failure of consideration is a defense pro tanto against an immediate party when the failure is an ascertained and liquidated amount in money. But it is not a defense against a remote party holder for value. A few decisions hold that a partial failure of consideration will not constitute a good defense in any case whether definite or indefinite. Total failure, as against an immediate party is a good defense, but not as against a remote party who is a bona fide holder for value without notice. Thus where the consideration of the note was that the payee should act as executor for the maker, and the payee died first, the note could not be enforced against the maker. So where a bill is drawn by one party on another payable to his own order, and is accepted, if the consideration fails as between these two, an endorsee for value who knows that the consideration has failed cannot sue the acceptor. Section 147. Illegality of consideration. Under the division illegality of consideration there are three classes of cases. 1. Those prohibited by statute, unless the statute renders the contract absolutely void. 2. Common law prohibitions. 3. Those against public policy. Where the consideration is illegal in whole or in part it is a defense against the entire note while in the hands of an immediate party or one who is not a bona fide holder for value without notice. In general, the consideration for a bill is illegal when it is wholly or in part immoral, contrary to public policy, or forbidden under penalties by statute. A distinction is to be made between a consideration simply illegal and one which by statute expressly makes an instrument void. In the former case a bona fide transferee may recover, though not in the latter. Where an instrument is given for a consideration which the statute expressly makes void, the party who gave the paper may set it up as a defense against all the holders whether immediate or remote, but the holder can sue the endorser. It is no longer customary by law to make notes expressly void by statute, and where such statutes do exist a clause frequently saves the rights of innocent holders. The holder of commercial paper is prima facie presumed to be an innocent holder for value, but where there is evidence affecting the bill or note with fraud or illegality, the burden of proof is shifted to the holder to show that he is an innocent holder for value. In case the holder can show that he paid full value, the defendant must then show that the holder had notice of the fraud or illegality. So it is held that where the holder has in good faith given part value he may recover to a like amount. Commercial paper based upon considerations which contravene public policy are void. Among such considerations is that for the purchase and sale of so-called bohemia notes at an exorbitant price, where one gives a note to another and for the reason that the other has committed a crime or will commit a crime, such note is a violation of the common law and there can be no recovery on it. That is, it is a personal defense which can be set up. Section 148. Payment. Payment in due course is the discharge of the instrument and is a good defense, but payment by one secondarily liable is not a discharge of the instrument. If a person makes an instrument and it becomes due and payment is made, then it is discharged, but if he purchases the instrument and it is not intended as in payment, it is not discharged.